Hi, this is Dr. Coleman, and I'm going to be talking in this clip about search and seizure. These are very critical issues for school executives because with the advent of drugs and weapons on campus, as well as zero tolerance policies, which most school districts have, it's very important that you understand the process as well as the student's rights and then your authority as a school executive. Search and seizure really comes under the Fourth Amendment, and I'd like to refer to my notes that the Fourth Amendment states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And in the letter of the law, that means probable cause. If you've ever watched some of these cop and TV shows with attorneys, when they go for a warrant, they always say, do you have probable cause? Well, probable cause means that I have a preponderance of the evidence that there's a weapon or drugs inside this household or somewhere, so that the judge gives me the warrant. Well, in the TLO case in schools, this tested the idea of probable cause. A young lady in a high school was accused of having cigarettes, and in the process of searching her purse, they discovered marijuana and charged her with that, and she was suspended. The parents of the student filed a lawsuit and said, wait a minute, you didn't have probable cause to look for the marijuana, you were just looking for the cigarettes. And this established a landmark case, the TLO case, where in the process of conducting a search, school officials, if they find something related to that, even though they weren't looking for that other item, they have the right to charge the student with that and face those consequences. So this is where the term reasonable suspicion was developed in the courts, that because school executives are charged with children, primarily all of them minors, they have the right to act on reasonable suspicion, and it's a much less standard in terms of probable cause. Now, the police could not do that, but as a school executive or principal, I could go in, as long as I have reasonable suspicion, I can go ahead and search and charge the student with whatever I find. There's a two-pronged test with it. When you do conduct these searches, make sure that the search is clear in its inception, that when you begin, you know you're looking for this based on a comment or a note or some evidence. And then second, that you stay within the scope of that. If I'm searching the young lady's purse and I find it, that's one thing. I can't say I'm going after the purse and then go over and go to the locker unless I made it clear that I was going to do both of those in the beginning. So that two-pronged test, reasonable suspicion, you should be okay. But again, it's very important to document this and always give the student the chance to give it up first. It's not necessary to conduct the search in the beginning. Ask the student to turn over what you think they may have, and 9 times out of 10, that's a much better way to go for you and the student.